Get ready for the dictation. Start. Heard Sri Gaurav Tripathi, along with Sri Syed Imran Ibrahim, Learned Counsel for the Appellant, and Sri H.N. Singh, Learned Senior Counsel, assisted by Sri Syed Fahim Ahmad, Learned Counsel for the Opposite Party. Stop para. The present appeal has been filed against the order dated 14 January 2021, passed by the Learned Additional District Judge, Court number 5, Gautam Buddha Nagar, Noida, Uttar Pradesh in SCC suit number 09 of 2019, bracket open, Messrs Nikon Systems Private Limited versus Tech Industries Private Limited, bracket close, stop. By the impugned order, the learned court has rejected the application filed by the appellant / defendant under section 8 of the Arbitration and Conciliation Act, 1996, declining to refer the parties to arbitration in terms of the registered rent agreement. Stop para. The fact giving rise in the present appeal, briefly stated, is that the opposite party, herein, is the landlord of the demised premises bearing number 38B, Udyog Bihar, Ecotech Second, Greater Noida, District Gautam Buddha Nagar. Stop. The property was rented to the appellant for business and commercial purpose for manufacturing sheet metal and engineering goods. Stop. The parties reduced the terms of the agreement-wide rent agreement dated 7 August 2018. Stop. Clause 13.5 of the rent agreement stipulated that in the event of a dispute arising between the parties, the matter would be referred for arbitration to a panel of arbitrators. Stop. Clause 13.5 is extracted, para. In the event of any dispute or difference arising out of or relating to or with reference to or in connection with sub-lease deed, including the termination of the sub-lease deed, the same shall be referred for arbitration to a panel of arbitrators, one to be appointed jointly by the two arbitrators so nominated, whose decision shall be final and binding on both the parties. Stop. The arbitrators so appointed shall give a reasoned award. Stop. The venue of the arbitration shall be at New Delhi, and the arbitration proceedings shall be in accordance with the Indian Arbitration and Conciliation Act, 1996. Stop. The arbitration proceedings shall be conducted in English language. Stop para. It appears that a dispute arose between the parties with regard to payment of rent. Stop. Aggrieved, the opposite party instituted a suit before the Provincial Small Cause Court seeking eviction and arrears of rent. Stop. The appellant, upon receiving the summons, filed an application under order 7th Rule 11 of the Code of Civil Procedure, 1973, contending that in view of the arbitration clause, the court lacks jurisdiction, accordingly, prayed that the plaint be rejected and the parties be relegated for arbitration as per terms of the rent agreement. Stop. The application came to be rejected by order dated 16 September 2019. Stop. Learned Trial Court, while dismissing the application under order 7th Rule 11, placed reliance on the decision rendered by the Supreme Court in Himangi Enterprises versus Kamaljeet Singh Ahliwalia. Stop. Aggrieved, appellant approached this court by filing a petition under Article 227 of the Constitution of India, being writ petition number 7446 of 2019, bracket open, Messrs. A Tech Industries Private Limited versus Nikon Systems Private Limited, stop, bracket close. The petition came to be dismissed by this court on 17/10/2019, upholding the order of the trial court, stop para. The appellant choose not to assail the order, consequently, the judgment and order passed by this court affirming the trial court order attained finality between the parties, stop. Thereafter, appellant within 30 days from dismissal of the petition under Article 227, appeared and filed a written statement on 5 November 2020, along with objection to an application filed by the opposite party plaintiff under Order 8th Rule 10 for rejecting the defense of the appellant, stop. Thereafter, appellant filed an application before the court below for referring the matter to mediation under Section 89 of the CPC, stop. The parties agreed to mediation, accordingly, parties were referred to the mediation center, stop. The mediation between the parties succeeded, stop. The settlement agreement was duly signed by the parties and filed before the court, stop. This fact is noted by the trial court in its order dated 23 December 2020, stop.